All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated, veuillez vous asseoir.
Good morning, everyone. Parties, participants, Mr. Said, good morning. Court officer, would you please call the case?
Good morning, Mr. President, Your Honors. This is the second situation in the Central African Republic in the case of the prosecutor versus Mohammed Said Abdel Khani, case reference ICC 0114-0121. And for the record, we are in open session.
Thank you very much. So this morning, our schedule will continue with the submissions from the statements from the representative of victims, the representative of PCV, Madam Counsel, the floor is yours.
Merci, Monsieur le Président.
Thank you, Mr. President. I really do not have any substantive observations. I do not have any substantive observations to make during this present session, but I will make my statements in my final statements that will be made subsequently pursuant to the time I was allotted in your decision. Thank you.
Well, thank you very much. Then we take note that you're announcing, making statements at this stage. Then, Madam Counsel, the floor is with the defense. You have 3.5 hours overall. So, yeah, a first chunk of 1.5 hours before we break. Please.
Merci, Monsieur le Président.
Thank you, Mr. President.
Comme nous l'avons rappelé lors de notre discours d'ouverture, le récit de l'accusation est parcellaire.
As we mentioned in our opening statement, the statement of the prosecutor is fragmentary, and the consequence is that they omitted important elements. It would be necessary to deal with the ins and outs of the events in order to understand the events. And before determining the judicial characterization of this situation, it is crucial because the judicial consequences that will arise from the qualification of the situation which prevailed in the CAR between March and September 2013 shall be important with regard to the basis of the charges alleged by the prosecution, and in particular concerning war crimes.
Et ma présentation sera appuyée
My
par
presentation will be supported by a PowerPoint so as to give it a bit of a structure. It will be presented on Evidence 2.
Alors, l'accusation, tout au long de son DCC,
Throughout its ZCC and the PCB, the prosecution postulates that, first of all, Seleka existed as a clear hierarchical and structured group, paragraph 11 of the DCC and 18 of PCC, that it was a group capable of carrying out coordinated operations. And secondly, that structure is supposed to have stood the test of time and became the state, paragraphs 20 to 26 of the PCB. In reality, as its name indicates, the Seleka is a mere coalition, which means an ephemeral alliance of people and groups for the purpose of making their voices heard, their grievances heard, in this case against the policies of President Bozizé. This alliance does not mean that all the participants are in agreement on how to resolve the discontent, and so consequently this coalition does not constitute an organization. It is for this reason that it is incumbent on us in the facts concretely to look into Seleka as an armed group, particularly because this issue was never discussed in an adversarial manner based on concrete elements. The reason motivating the creation of this opposition group, we know that the various groups making up Seleka were created to oppose President Bozizé. And this is document 93, 140, 141, and 148. The number of groups and leaders multiplied in the years 2000, document 93115 and 141. These groups were particularly numerous. The prosecution in its DCC paragraph 11 and PCB paragraph 13 gives a simplistic view of these groups, which was a circumstantial alliance, the Seleka, and did not have any specificities or leadership problems. So we can mention here all the internal fights, and we cannot talk about all the contradictions and internal contradictions, but we will give an overview. We will talk about the paternity claimed by the leaders of those groups, because this entity is complicated. We will choose the most revealing elements, the lack of cohesion and homogeneity. The first group, the creation of the FDPC, the Democratic Front, on the 15th of June 2004. The first president of the FDPC was supposed to be Abdoulaye Miskin. He's supposed to have created that movement on the 15th of July 2004 and signed an agreement with Bozizé on the 2nd of February 2007. From that moment, the fate of this movement was quite fluctuating. First of all, because the agreement was not, the peace agreement was not respected by President Bozizé. FCDCP launched an attack against FACA, which led to a new agreement on the 3rd of July 2009, document number 50. The enemies of yesterday became the friends of today. In January 2012, Abdoulaye Miskin fought alongside FACA. In January 2012, Abdoulaye Miskin fought alongside FACA, the forces of Bozize, against the movement of Baba Labe, document 158. And that did not prevent Abdoulaye Miskin later on from participating in a meeting in Niamey in 2012 in the presence of Michel Dotordia and Joachim Kokate, members of the CPGP, document number 125. After Niamey, Abdoulaye Miskin, Michel Jotodia, and Joachim Kokate are supposed to have put in place FUCA, the United Front for the Renaissance of the Central African Republic. It was a first alliance to fight against President Bozize, and that was done on the 15th of March 2012. However, Joachim Kokate immediately left that alliance and joined President Bozize. Document number 50. Subsequently, in autumn of 2012, Abdoulaye Miskin is supposed to have also participated in the same capacity as the UFDR, the CPJP Fundamental, and the CPSK in the creation of Seleka. Document 151. It is interesting to note that in March 2013, Abdoulaye Miskin left Seleka to fight against that same movement, and that in a communique dated 10th September 2013, Abdoulaye Miskin announced that his party, the FDPC, was joining FROCA, Front for the Restoration of Constitutional Order in the Central African Republic, which was a movement associated to President Bozize. Here we have a perfect example of the opportunism which guided the various groups and factions. Abdoulaye Miskin changed alliance based on developments in the situation in the car. Exhibit 151. Now, regarding the union of Republican forces, Florien Nage presented himself as the leader of the UFR that is supposed to have created after having been arrested and tortured by President Bozize. Document 82.
Au nom de l'UFR.
He signed the Global Accord on the 15th December 2008 on behalf of the UFR. However, the evidence on his group on the field is thin, and the representatives of the DDR responsible for disarmament acknowledged that this group never really existed. Document 141. It is interesting to note that we have contradictory elements, and some insider witnesses indicate that the UFR was reportedly not a part of Seleka. Document 321, line 260. Other sources indicate that the circumstantial coalition benefited from intermediate support of the UFR. Document number 45. Now let us go to the creation of the Union of Democratic Forces for Development, UFDR, which is supposed to have been set up on the 14th of September 2006. The UFDR is one of the most emblematic groups which later participated in the Seleka coalition, but it is also one of the groups for which contradictions are numerous. The information at our disposal provide very different information regarding the paternity of the group and its members who kept on opposing each other and fighting against each other. I will refer you now, amongst other things, to the following references. P413, paragraph 48. Exhibit 320, lines 852 to 855. Document 141, pages 430 to 432. Document 131, page 125. Document 50, page 163 and 164. Document 46, document 125, and page 320, pages 980 and 999. Let us take an example. Some witnesses state that the UFDR was created by Michel Djotodia and Daman Zakaria in 2006, specifically P413 and P1019. Other well-informed sources explain that from the outset, the groups making up this union were composed by armed men from rural areas who were uncentralized, and they made up flexible alliances before transforming themselves into rebels. Document 141. Because of monetary reasons, there were skirmishes between the various groups, and that led, after 2005, to Gula leaders, including Daman Zakaria, to create an alliance with Abaka Sabone, another former liberator who had turned against President Bozize. Now, given that Abaka Sabone was in Cotonou, in consideration of the facts, it seems that it was Daman Zakaria who was in fact the leader of the UFDR. Document 141. Other sources indicate that the UFDR was allegedly led by Florian Njade, who claimed attacks that took place between 2005 and 2007. Document 131, page 125. It is also interesting to note that while Michel Djotodia was jailed with Abaka Sabone in Benin, Damane Zakaria signed an agreement, a peace agreement with Bangui in April 2007, and thereafter Daman Zakaria was appointed into the government of President Bozize, and this was disapproved by Michel Djotodia, and that led to confrontations between rival factions of the UFDR. Document 50.
Michel
Djotodia dismissed Daman Zakaria in May 2008 and replaced him by Yunus Ouma and Joseph Zundeko. Document 50. It is interesting to also note that shortly after June 2008, Abaka Sabone left the UFDR, and he had been the spokesperson of that movement, but he took over the MLCJ in 2008. Document 50. Abaka Sabone changed camps on several occasions, document 125. This information shows clearly that within the same group there were serious disagreements, and it is practically impossible to establish who was the leader of the group because the final objective of everyone was to accede to positions of power that were financially beneficial. Now, I will go to the creation of the Convention of Patriots for Justice and Peace, CPJP, in 2008. It was never a unanimous decision, and its internal functioning was characterized by constant power struggles. A source with special information indicates that in 2008, DAFAN is supposed to have created the Convention of Patriots for Justice and Peace, CPJP, with Noureddin Adam. It was supposed to be a political party, P413, paragraphs 49 and 51. More specifically, the CPJP was allegedly created by Dafan and Issa Bouma, the uncle of Noureddin Adam, P413, paragraphs 53 and 54. Dafan then took over the political leadership of the CPJP, but allegedly was not aware that Noureddin and Ali Muhammad Daba and Al-Bashar Fadul, whose father is the uncle of the mother of Dafan, were organizing combatants in the field, P413, paragraph 60. Other well-informed witnesses stated that the CPJP was created by Noureddin Adam and Abdoulaye Hissène, document 321, page 1028, and that there was a disagreement between these two men which led to the creation of the two wings of the CPJP, P0291, paragraph 51, and that subsequently Charles Massy took over the movement.
Ce ne serait qu'à la suite du décès de Charles Massy.
It was only after the death of Charles Massy that Abdoulaye Hissène and Noureddin Adam fought against each other to take over the leadership of the CPJP, P413, paragraph 61. According to others, the CPJP is supposed to have been created by Charles Massy after having been a minister under President Bozize, document 141, page 432. With regard to Abdoulaye Hissène, he supposedly remained at the CPJP and allied himself with President Bozize for the purpose of fighting against the Seleka, document P1019, page 1029. It is interesting to note that certain elements indicate that the UFDR and the CPJP, which were temporarily allied within the Seleka, confronted each other against a backdrop of ethnicity between the Gula and the Runga for the control of territories and resources. Document 45, page 1892. Several materials at our disposal illustrate the internal chaos within the CPJ and their relationships with the other groups. And here I refer to Exhibit 141, page 142, document 45, page 1892, document 47, page 27, document 50, page 163, document 35, page 249, document 92, document 68, or rather document 72, document 68, and the testimony of P291, paragraph 51. In the final analysis, who amongst Abdullah Hussein, Nureddin Adam, Charles Massey, and Muhammad Zakaria created the CPGP and was the leader who had the authority to sign agreements on behalf of the CPGP. One last word on the creation of the Patriotic Convention for the Salvation of Kodro, the CPSK, in June 2012. Dafan is supposed to have created the CPSK in June 2012 after having been a member of the CPJP, document 50, page 164, and document 12. And yet, other information in the case file show that Dafan was a member of the UFDR on an individual basis without his own group, and that the CPSK never existed, document 321, page 1031. According to others, Dafan simply coordinated the action between the former comrades of President Bozize who had fled and the UFDR, document 320, page 0998. Whatever the case, the power struggles internally between Mohamed Musa Dafan, Michel Jotodia, and Nureddin Adam created situations that were complex and difficult to follow, even well after March 2013. We will refer you to the following documents: number 125, number 385, number 50, number 77, number 143, number 112, and number 95. Each group that was a part of the coalition from the very outset experienced internal conflicts, and yet the prosecution does not mention that. They behave as if the various groups were clearly defined and that they had the capacity to coordinate themselves, and yet nothing could be further from the reality. For example, why does the prosecution not mention that the CPGP was created independently from the UFDR and that from the very beginning there was a power struggle at the head of the CPGP? Upon analysis, it seems that these groups were disparate and that it was a hodgepodge of different groups that did not coexist in a peaceful manner. The internal struggles and external struggles added to the fight for legitimacy to be recognized as opposition. The legitimate opposition to the government prevented any form of coordination. The levels of division were not resolved by the temporary coalition of these various groups. And this is what was referred to as the Seleka. This was an opportunistic creation in reaction to the government of President Bozize. The only element that brought together in an ephemeral manner part of these groups, which operated independently from each other, was their discontent against President Bozize. So this was a mixed basket of a coalition which was joined by other groups subsequently. Document 27. Sometimes Seleka was created as a regional movement, and according to Roland Marshall, a researcher in Série Sciences Po and a specialist in the car, they were, and I quote, nothing more than a federation of armed groups that were themselves poorly structured without any real chain of command. Document 113. So there was no hierarchy between the Seleka groups. The elements that made up the different groups were scattered in the various zones and even in other movements, and their numbers were insufficient. Document 152. It appears that in reality, these groups came together in 2012 for a single reason, that is to participate in the Libreville Summit on 11 January 2013. It should be noted that in February 2013, that is 1 month after the Libreville Accords, the presidential camp multiplied its provocations, and in March 2013, President Bozize did not respect the Libreville Accords. President Bozize even announced during a ceremony to celebrate his 10 years in power that he would be once again a candidate in the upcoming elections, which was in contradiction with the Libreville Accords, P291, paragraph 58, document 407 and document 146. Now, regarding the circumstances of the arrival of Seleka in Bangui, it was not a coordinated military operation. The prosecution postulates that what they refer to as Seleka reportedly succeeded in capturing Bangui, and they put that forward as evidence that Seleka was capable of organizing themselves, paragraph 18 of the PCB. This attempted explanation a posteriori does not stand up to analysis. The evidence relied upon by the prosecution show that the arrival in Bangui was not coordinated. Nothing was organized and nothing was planned. The evidence is clear. Those who are supposed to have been the masterminds behind Seleka, those who were supposed to have been giving orders according to the prosecution, were taken hostage in Bambari by UFDR elements. P1019, lines 1545 to 546. Document 407, paragraph 24, and P291, paragraph 63. This hostage taking took place in the days preceding the advance towards Bangui, and these people were maintained incommunicado during that period, P291, paragraph 63. And these so-called people who issued orders learned over the radio that the groups making up Seleka were advancing towards the red line and in the direction of Bangui. Document P1019, pages 1041, 1053, 1054, and 1061. It is evident from the evidence that it is not clear who gave any orders at all. Document 321, lines 1573. An insider witness states clearly, and I quote, "What happened between the international community and Seleka, God alone knows." Document 321, lines 1249 to 1251.
Dans un tel contexte,
in such a context, it is difficult to imagine the existence of any sort of chain of command. P1019, who is a well-informed source, indicates that President Jotodia was not aware of the military chain of command, because he arrived Bangui only after the groups that made up the Seleka alliance had already arrived. Document 320, lines 1508 to 1513. And that President Jotodia was not aware of what had happened before his arrival in Bangui. Document 320, page 1008. In the same vein, none of the high-ranking dignitaries of the so-called Seleka received any report related to the incidents involving South African elements, during which the person who was supposed to be the chief of military staff, Issa Isaka, was injured. Document 320, page 1019, line 1624. It was only after Issa Isaka went to Sibut that the leaders of the biggest parties of Seleka became aware of that isolated incident. Document 321, page 1059, and this clearly proves the absence of a structure and a chain of communication. The prosecution prefers to ignore the testimonies coming from well-informed sources and states in its PCB that the capture of Bangui in 2013 was methodically planned by the military leaders, the high-ranking military leaders of Seleka, amongst others President Michel Jotodia, Noureddin Adam, and Mohamed Musa Dafan. End of quotation, paragraph 19 of the PCB. And this paragraph 19 is based on a single witness, that is witness P0776. Now, regarding witness P776, we are going to consider that the decision of the chamber from the moment when there was no longer any possible contact with him, the chamber will therefore not rely on his statement. This information coming from 776 is moot. Regarding P1167, who came to corroborate P776, but the prosecution did not refer this in the PCB, but in a submission because the case was weak. So this witness reported a hearsay from someone from a third party who himself had heard only about what had been discussed. The prosecution feels that they can lay the foundation for such an allegation based on an anonymous statement and on hearsay, which are both sources with very low probative value. And yet the prosecutor has in their disposal information indicating the contrary, and they did not find it useful to present that information to the chamber. And it was also based on hearsay reported by P1167 that the prosecutor based his allegation according to which the above-mentioned military leaders met to draft an operations plan. And yet P1167 clearly indicates that he heard about the plan, and I quote, to capture Bangui through a person that he describes as a Seleka rebel who himself had heard about that plan from a colonel who is supposed to have participated in a meeting. There is therefore nothing tangible. This is second-degree hearsay. This double anonymous hearsay is the only source used by the prosecution that is supposed to have made it possible to prepare a plan by the various groups in order to advance to Bangui. And yet we have seen that there is an abundance of evidence to the contrary, coming amongst others from the statements of the highest ranking officials and the most informed individuals. Now, once the groups making up Seleka arrived at Bangui, what happened? Michel Djotodia, who was not in Bangui, finally went from Sibut to Bangui in the afternoon of the 23rd of March 2013, document 320, pages 1007 and 1008. It is important to note here that on the eve of that day, Michel Djotodia had received international representatives, lines 624 to 658, and lines 747 to 802. Djotodia had received international support, particularly the support of the ambassador of France, document 320, lines 1888 and 1891. Document 329, lines 268 to 272. On the 24th of March 2013, Michel Djotodia proclaimed himself as the President of the Republic, and very quickly the situation was formalized and led to the creation of the National Transitional Council on the 13th of April 2013. So this was the creation of a government of national union, not a Seleka government as claimed by the prosecutor.
Since the 31st of March 2013, President Djotodia nominated a union government. I refer to Exhibit 2004/1597, page 1605 to 1607, Exhibit 45, and Exhibit 407. The government of the National Union was made up of 34 ministers. Only 9 of them were officially affiliated to the ex-Seleka, Exhibit 45. Yet, the prosecution is not really interested in the reality of this government, which was made up by President Jotodia, and focused solely on the nomination of former members of the alliance, which was the Seleka, paragraph 20 of the PCB. But if we analyze the material which the prosecution submits for this assertion, it appears clearly that here is a government of a national union which is made whilst respecting the Constitution and the Liberal Agreement of the 11th of January 2013, Exhibit 287. A government with Nicolas Tongai as Prime Minister. P291, who has a unique position, indicates, and I quote, all the groups who participated in the Libreville Summit were represented in the transition government, including the ministers of the former regime of Bouzizi. Paragraph 75. By applying the presidential decree number 13.011 to 13.009, this is Exhibit 2004-1597, personalities with a profile of experts in the area which represented the civil society were also appointed. For example, Arsène Sendé, magistrate who became Minister of Justice, or Charles Armel Douban, former ambassador of the Central African Republic at the United Nations, became the Minister of Foreign Affairs. Exhibit 407. In these circumstances, to talk about a Seleka government does not reflect reality. As regards the National Security Council, the proceedings carried out by the prosecution is the same. They only mention Noureddine Adam as one of the members, but omit to specify that the presidential decree, which the prosecution refers, which is on the footnote of the PCB, states that this council is made up of several ministers representing very different affiliations. On 13 positions, only 3 former Seleka. Especially, what the prosecution does not say, that Comforce of FOMAC, the attaché of the defense for France and the mediator representative responsible to resolve the crisis in the Central African Republic, were also part of this body and were there to be consulted. It's as if the prosecution looked at the security context which existed in Bangui at the moment of setting up of that council, and as the name indicates, is a National Council for Security. And it's also as if it seems to be oblivious of the security context generally. President Jotodia had never denied that the Security Council exists since March 2013, and that was very difficult. As soon as he took over the functions, the bandits and spontaneous individuals suddenly cropped up within the Seleka because they hoped to obtain advantages through that. Exhibit 321, line 267 to 282. Exhibit 149, page P
2841, paragraphe 83.
2841.
P 2563.
P2563, page 703.
Pièce
Exhibit 155.
Pièce
Exhibit 153.
et pièce
And
262.
Exhibit 262.
Dans le même sens,
In the same way,
président de Toja,
President Djotjeteria, as well as the Prime Minister Tiangai, publicly intervened to explain that the elements from the ex-Seleka must be billeted to avoid problems of criminality. Exhibit 320, line 1778 to 1795. Exhibit 321, line 1466 to 1482. We should note also that individuals were looted because they pretended to be elements of the Seleka, Exhibit 180 and Exhibit 155. As P234 stated, a man of law, des gens without belief or law suddenly became Seleka. P0234, paragraph 68. President Djotjeteria decided to try and disarm the elements of the Seleka coalition. Exhibit 261, Exhibit 320, line 1776 to 1820, Exhibit 321, line 1474 to 1481, and line 1598 to 1609. President Djotjeteria then went against and visited the leaders of the neighborhoods to try and disarm the various areas in Bangui. Exhibit 2. In May 2013, the Prime Minister announced that the combatants who did not obey, be they Seleka or former members of FACA, would not be authorized to hold arms and had to hand them over as soon as possible before they would go to the barracks outside Bangui. Exhibit 45. It should be noted that on the 12th of September 2013, President Djotjeteria announced the immediate dissolution of the Seleka coalition, Exhibit 26, and he took a decree to formalize this dissolution, Exhibit 160. Article 2 of the decree specifies that all individual who was acting on behalf or in the name of Seleka and the CPGP would be subject to sanctions. It therefore becomes apparent that the state didn't have any impacts on the different groups present in Bangui. In particular, an expert commissioned by the prosecution in the case Yekatoma Nagaisona indicates, and I quote, the Seleka was a circumstantial coalition of armed groups. The reality of power did not find itself in the government of Michel Djotjeteria, Nicolas Changai, but with the commanders, amongst them, the hierarchy and the discipline was quasi-inexistent. On the one hand, the Seleka was ingovernable because of the absence of internal discipline. On the other hand, it was not capable of governing because the armed groups which made it up did have only one aim, to oust President Bouzé's aim, and they did not have people capable of running the country. They were barely functional. The government did not have any authority on the Seleka commanders. Even the political representatives of Seleka had no influence on the commanders, and amongst themselves, they didn't obey each other. The different armed groups did not only recognize the authority of their direct leader, Exhibit 407. This is an expert of the prosecution, Ronald Marshall, who is a well-informed individual who was responsible for research in the CRNS, explains the Seleka as follows, and I quote, "There was no real political control. It was rather a federation of armed groups who they themselves were weakly structured, without a real chain of command." Exhibit 113. In the same vein, Clotaire Soleil Surumba states clearly, and I quote, "However, it is easy to confirm with force that after the 24th of March 2013, the leaders of the Seleka, as well as the President of the Republic, Michel Duterte, lost control of his men, both at Bangui as well as in the interior of the country." Exhibit 137, page 73. He also explains that the so-called different ranks of the different individuals were self-imposed, and I quote, "The Seleka combatants did not recognize any hierarchical authority, and their military culture was such that they had a preference for the rankings of captain, colonel, and general, which they gave themselves." One could see a colonel seated in the back of a pickup with a captain comfortably seated in the passenger seat of a vehicle driven by a general. The officials and the senior ranking individuals of the administration had no relevance for these new masters. End of quote. Exhibit 137, page 74. Testifying before the American Congress, an expert indicated, and again I quote, "There still is no internal cohesion within the Seleka movement. The Seleka is born from a coalition of combatants coming from rebel groups which have existed already for a long time, and historically they are against each other, and they conflict with each other without any loyal troops to individual commanders, with a poor hierarchical system. There is no agenda, no ideology, or political platform which is consistent behind the Seleka movement, apart a general feeling that the northern part of the country was historically overlooked. Apart from that they were principally Muslims and motivated by opportunism, there was not a lot which the Seleka movement had in common. The absence of internal control meant that it was difficult for the political leaders to have any impact on the various arms of the movement. Exhibit CAR-OTP/2081, page 0531. Similarly, the defense refers to Exhibit CAR-OTP 2001-1767, page 1779, P0291, page 0048, Exhibit CAR-OTP 2081-0496, page 0531, and Exhibit 113, page 7. Sorry, page 0007. In such a context, it's very difficult to understand why the prosecution qualifies the OCRB and the CEDAD as a Seleka base, paragraph 21 of the PCB. In analysis, it appears that the OCRB and the CEDAD is in the state structure which was attempting to run smoothly. From the available material, it seems that the OCRB is an office which pre-existed the government of President Jotodia. Exhibit 115, Exhibit 323, line 1472, P0338, page 5764 to 5767. This not only existed but was included in the state structure and which continues despite the difficult conditions to fight against widespread banditry. P1167, paragraph 59. Let me remind you that the OCRP is managed by General Louis Mazangué. Exhibit 323, line 1460 to 1466, Exhibit 328, CAR-OTP 2093-1342. Furthermore, some witnesses, such as P01019, as the one who was behind the OCRB, Exhibit 323, line 1460 to 1466. The OCRB was under the authority of the General Direction of the Central African Police. And here I refer to CAR-OTP 2034-3653, page 3654. The direction of the General Police of the Central African Republic was under the authority of the Minister of Security. And here I refer to CAR-OTP 2034-1740. And Exhibit 323, line 149 and line 190 to 199. The OCRB, above all, is a police office which is included in the state structure and which should step in a period which had a high rate of criminality and delinquency. The witness 1167, which the prosecution refers to frequently states the following, and I quote, "The OCRB had to intervene when there were serious crimes committed, including violent crimes, for example, theft by which was carried out with arms. The sergeant police already existed in the past. The OCRB staff received telephone calls from the public on that particular line. The people pointed out offences, principally theft, and the staff of OCRB intervened, often in situ." Paragraph 58. Furthermore, OCRB got to know, and I quote, "there were frequently offences between citizens, as well as pointing out offences committed by the Seleka, such as theft and looting, where the Seleka of the OCRB also took action." Paragraph 59. Which is also confirmed by French military, which is CAR 2116-0776. As regards the way in which the OCRB functioned since March 2013, let me remind you here that at the very beginning, when the transition power became in operation, almost all the FACA or police had fled, and there was a serious lack of staff. This is 2093-1185, line 1439 to 1453. The OCRB was understaffed. That's the reason why the position of the transitional government was that even if the duty police took their work, other voluntary elements who were present must stay there to offer support. And it's one of the insider witnesses who says this, Exhibit 32321, line 1421 to line 1453. Consequently, the individuals in OCRB under the direction of Mazangué were not Seleka, but voluntaries who tried to help in a chaotic situation where there was banditry taking place at an alarming rate. This situation created chaos within the OCRB, where it was impossible to establish who was in charge. There was no hierarchical structure. It was simply impossible to know what sort of hierarchical structure existed. There were a lot of individuals who were trying to take action to fight against banditry. P234, who knew what was going on and said, and I quote, "You asked me who was at the head of the OCRB. It's difficult to say because it changed all the time." Paragraph 98. And I stress the importance of this witness, who is in a good position to understand what was going on. From the evidence of the prosecution, there was a structural function in the OCRB, which, as a result, it was impossible to know who was the head of the OCRB. We'll come back to that a little later on. But we should note now that the OCRB worked together with the prosecution of the Republic. Many witnesses corroborate this. When analyzing this, that despite of the poor means available to the OCRB and the constant chaos, the OCRB worked together with the prosecutor of the Republic to make sure that arrests and detentions were part of a judicial review. We will go back to that a little bit later today, and we'll quote many witnesses who can uphold this. According to the prison population of the OCRB, P2239 states, and I quote, "The majority of other prisoners were all young delinquents in Seleka who were accused of theft, drug trafficking and breaking in." Paragraph 48. P0885 states, and I quote, "The Seleka who committed crimes were taken to the OCRB." Paragraph 53. And he continues, "When there was an arrest of a member of the Seleka, when took that person to the SRI or to the OCRB. There were police and gendarmes in those locations. The local population called us to tell us about crimes." Paragraph 49. P2563, as far as he was concerned, he had the following explanation. Answering the question, "Can you give us an example of the type of offences committed in order to be imprisoned in the OCRB? Do you have any examples?" The answer, the majority of the time they looked at the cases of the people, they took drugs, they stole things, and they drank too much alcohol. And therefore it's very difficult to understand how the prosecution bases its arguments on the OCRB was a Seleka basis, whereas it's a location where delinquents and criminals were held and were imprisoned. A strange base for the Seleka if it was to imprison the ex-Seleka by demanding Seleka and to submit them to a judicial review, which was normal because they were presented to the prosecution of the Republic. Turning to CEDAD, the former National Bureau of Documentation, BND, which became the Extraordinary Committee for the Defense of Democratic Rights. Here, it had the same function of the OCRB. It had a state structure. So, let us look at the analysis. It appears that the first criteria to allow us to qualify this as an armed conflict, the situation in the Central Republic of Africa between March and September 2013, are not met. The prosecution, under general expressions such as the Seleka, cannot sidestep the reality that there was not, between March and September 2013, an organized group capable of carrying out military operations. The reality is that this was a coalition grouping a nebulous group of dissatisfied individuals who were unhappy with Bozizé, who went to Bangui to express their dissatisfaction, which led to the resignation of Bozizé. And so, between March 2013 and December 2013, a transitional government attempted, in a very troubled context and internal tensions, to stop isolated and sporadic actions of violence. Furthermore, the witness 0234, a man of law, says the following things. You're asking me to explain the chain of command within Seleka. That makes me laugh. What chain of command? I must refer you to Duterte to ask him to clarify this. There were many nationalities in the Seleka, like Chadians, like Sudanese, etc. Each of these commanders had his own men. You can talk about a deregulation of the command chain. End of quote. Paragraph 92. Since the prosecution was not able to establish substantial grounds to believe that there was an armed conflict during the period where this took place, within the OCB, all allegation of war crimes cannot be confirmed. Now, nevertheless, we look at the intensity and the continuity which is alleged of the so-called armed conflict, as well as the question of who would be the other party of the so-called conflict, so that we can answer exhaustively the arguments put forward by the prosecution. As regards the judicial qualification of the situation which reigned in CAR between March and September 2013, I would like to point that one of the bases of the argumentation put forward by the prosecution, that there was an armed conflict of a non-international character which started in December 2012 and which was followed uninterruptedly during the period in question, which in one part was the Seleka and the others the pro-Bouzezé group, which was composed of anti-Balaka, paragraph 8 and 9 of the PCB. Of course, well aware of the weakness of this argument and the complete unlinking with or not reflecting reality of what was happening on the ground, the prosecution tried to sidestep the difficulty of the temporal time of the armed conflict in the first paragraphs of the PCB, because it starts by explaining why the report of the International Commission of Investigation on the CAR from the United Nations and said there was no armed conflict between March and September 2013 and stated that this was erroneous. In this report, the United Nations experts, after a very careful factual analysis of the situation, said that the level of hostility between March 2030 until the beginning of December did not reach the level to be regarded as an armed conflict. And here I refer to CAR O2P 2001, 7017, paragraph 96. The prosecution puts forward this report as if it's the sole document where there was a single position, forgetting to specify that the legal conclusions of the investigation commission was based on an analysis of statements made of the CICR. ICRC. In fact, the United Nations report stresses a change in legal qualification of the situation in CAR operating by the ICRC between 2012 and 2013. In fact, in 2012, an armed conflict, non-international, was identified by the ICRC, whereas in 2013, the ICRCR did not identify any armed conflict and mentions the presence car,
non pas de combattants,
not of combatants,
mais je vais la citer en anglais,
but, and I'll quote in
mais
English,
de
the two
weapon bearers.
weapon barriers,
Que le CICR
which
invite
the
à
ICRC
respecter
invites
leurs
everyone
obligations
to
en matière de droits de
respect their
l'homme.
obligation as regards human rights.
En matière de droits de l'homme,
As
ne
regards human
mentionnons
rights,
pas
and does not mention
l'existence
the
d'obligations
existence of
en matière
obligation
de
as
droit
regards
international humanitaire,
humanitarian international law,
ce qui aurait été le
which
cas
would have been the
s'il y avait
case
eu un conflit armé
if there
non
would have been
international.
an armed conflict of a non-international nature.
L'accusation ne suit pas les conseils des Nations Unies
The
et tente
prosecution
malgré tout,
didn't
dans son
follow the
DCC,
advice of the United
d'établir
Nations and
qu'il y
attempts
aurait
to
en
say
2013
that in
un conflit
2013
armé non
there was
international
an armed conflict of
de
a
manière
non-international
complètement
character
déconnectée
which was
de la
completely
réalité
disconnected
des
to the
faits.
reality of the
et que
facts,
personne,
and that no one,
ni les Nations Unies,
neither United Nations
ni le
nor the
CICR,
ICRC,
ni les
nor
ONG
the
spécialisées
NGOs
du
who are
DIH,
specialized in human rights
du droit international humanitaire, ne vient soutenir.
could support.
L'accusation
The
renvoie aussi,
prosecution also
en note de
refers
bas de page
on the
31,
footnote page, on the page
à la
31,
décision de
to the
confirmation des
decision
charges
of the
dans
confirmation of
l'affaire
charges in the
Yekatom
case
et Nguessola,
Yekatom and
qui
Negasona,
contredit sa
which
position.
contradicts its position.
Et je cite,
And I quote,
la
The
Chambre
Chamber
considère qu'il existe des motifs
considers that there are
substantiels
substantial grounds to believe
qu'un conflit armé
that an
ne
armed
présentant pas un
conflict
caractère international
of a non-international character
au sens
within
des alinéas
the meaning
D et
of
F
lines D
de
and
l'article
F of
8.2
Article
du
8.2 of the statute
s'est déroulé
took
sur les
place
territoires de la RCA
in the CAR
septembre
territory from
2013
September
jusqu'en
2013
décembre
to
2014,
at least December 2014,
entre
at least
la
between
Seleka
Seleka
et les
and the
Antibalaka.
Anti-Balaka.
Paragraphe 72
Paragraph 72
de l'écriture
of the submissions
18-403.
of
Il est
18403.
intéressant de noter que
It is
l'accusation
interesting
se
to point
réfère
out that the prosecution refers
dans les sections
in the sections
consacrées
devoted
aux
to the
Antibalaka
Anti-Balaka in
dans le
the PCB,
plus ou moins aux
more or
mêmes
less to the
témoignages
same
et
witnesses
éléments de
and
preuve sur
evidence
lesquels la
on
Chambre,
which the
dans l'affaire
chamber in the
Yekatom et
case
Nguessola,
Yakatom and
s'était
Nagasona
reposée
relied
pour décider
for
que le
its
conflit
decision
armé
that the
non
armed
international
conflict of a non-international
commencer
character
qu'à partir
started
de septembre
only
2013.
from September 2013.
Pourquoi aujourd'hui le résultat serait-il
Why
différent?
should the results be and the outcome be different today?
Surtout,
Above all,
l'accusation
the prosecution
omet d'indiquer que
forgets
sa
to point
position
out that its position
n'est, à la
isn't,
connaissance de la défense,
as far as the defense is aware,
soutenue
upheld
aucune
by
autre source
any
qu'elle a pu
other
identifier.
source which it could identify.
Ainsi,
Moreover,
en plus du rapport
in
de
addition
l'ONU
to the United Nations
CICR,
report and
et
that
de la
of the
jurisprudence de
ICRC
cette Cour,
and the
qui contredisent la
jurisprudence
position
of this
d'accusation,
court, which contradicts the position of the prosecution,
les professeurs Casey Malson
the professor Casey
Haynes
Melson and Haynes,
écrivent en 2018
writing in 2018
Hague Law
in the Hague
Interpreted,
Law Interpreted,
the conduct of
the
hostilities,
conduct
under
of
the law
hostilities
of armed
under
conflict,
law of armed conflict,
qu'il existe
state
de
that
forts
there
doutes
are
qu'il existe en
strong
RCA
doubts that
un
in the
conflit armé
CAR there's an armed
après mars
conflict
2013.
after March 2013, page 54.
Dans le même sens,
Similarly,
Tillman
Tillman
Rodenhauser,
Rodenhauser
dans
in
Organizing Rebellion
Organizing Rebellion
en 2018,
in 2018
reprend à son compte
also
les conclusions de la
resumes the
commission
conclusions
d'enquête des
of
Nations Unies.
the Investigation
Page
Commission of the
200.
United Nations, page 200.
Le War Report annuel
The annual War
2013,
Report of 2013,
publié par
published
Oxford
by
University,
Oxford University,
l'une des références en la
one of the
matière,
references in this material,
indique
points out
que la violence armée
that armed
en
violence
RCA
in CAR
depuis avril
since
2013
April
ne constitue
2013
pas un
does
conflit
not
armé,
make up an armed conflict in accordance with international law, as the groups involved did not fulfill the criteria of the organization. Page 105. Anissa Bellal, who was legal advisor with the High Commissioner of the Human Rights of the United Nations Rights in 2014, with the effective disappearance of one of the two parties to the conflict, IHL ceased to be applicable in CAR from the 25th of March onwards, with the effective disappearance of one of the two parties to the conflict. Under these circumstances, it is not surprising that in the following PCB, the prosecution has difficulties in proving these allegations. Evidence, in fact, supports the contrary. Therefore, when the prosecution asserts from paragraph 32 of the PCB and onwards, and I quote, the pro-Bozizé forces maintained efficient commanding structures adapting to the current circumstances, end of quote. It refers us to sources which confirm that, one, the anti-Balaka movement was only being organized as from the summer 2013, and above all, secondly, the clashes only started from September 2013. Thereby, to look at some striking examples, in the report of the Commission's report of the United Nations of 2014, which the prosecution refers to in the footnote of page 82, it is mentioned that, and I quote, the first traces of the anti-Balaka were seen in the town of Bossangoa in September 2013. But it was only on December the 5th, 2013, when they attacked Bangui, that the anti-Balaka demonstrated that it had the capacity to conduct a military attack. Paragraph 286. It is exhibit 2001 7017. The IPIS report, where the prosecution makes reference on the footnote page 82, and I confirm, around 2013 in August, these groups were set up and attacked Seleka in and around the Bossangoa and Buka in September. Exhibit 2001-5739, page 5782. Final example. As regards witnesses which the prosecution refers to, the majority do not give reference to any date or only talk about the beginning of the organizations of the anti-Balaka, which started only in the summer of 2013. One of the witnesses which the prosecution refers to in its PCB, P0889, paragraph 24, describes the setting up of what it calls a self-defense group in Bangui, where the mode of action was to bang pots when the Seleka arrived in their neighborhood. One is far here from reaching the criteria of an armed conflict of a non-international character. I can see time is against me, but I have only 1 minute to conclude.
Please.
The prosecution is not any more convincing when it says there's a continuity in the combats which took place after March 2013. They point out that 6 months after the eviction of Bozizé, the anti-Balaka carried out coordinated attacks, which were more intense against the Seleka and Muslim members of the civilian population in the western part of Kar. The culminative point was the offensive of the 5th of December 2013 in Bangui itself, paragraph 29 of the PCB. Either, therefore, in the month of September, 6 months after the eviction of Bozizé, it was the month of September, and it continues because of the reorganization, the pro-Bozizé forces, which also had FACA elements who remained loyal to Bozizé, managed to carry out coordinated attacks within the second part of 2013, paragraph 37, conceding through this that there is no evidence to support the existence of an armed conflict before summer. Furthermore, the only example which the prosecution gives before September 2013 is contained in the assertion that there was an investigation of that there was an attack on the National Assembly in Bangui. The aim was to cause disruption of the second investiture of Jotoja in August 2013, paragraph 37. It suffices to read the witnesses which the prosecution refers to understand that what he calls these forces, by trying to creating a feeling of an enormous organization, was in reality a few former FACA who had not left Bangui in March 2013 and who hid in Boiraib. For example, witness 0119 talked about symbolic resistance of the local FACA in Boiraib, P0019, paragraph 67. In conclusion, these actions, which were localized in Bangui, led by a handful of individuals, and only a handful of individuals, and these actions were sporadic, according to the evidence of the prosecution themselves. There were 2 incidents, one in April and the other in August. These actions cannot really justify the existence of an armed conflict of a non-international character in the period of March to September 2013. Thank you, Mr. President.
Thank you very much, Madam Counsel. Now you deserve some rest, as well as our excellent interpreters. We'll break for half an hour. Now, all being well, your time will end around 3 p.m. So OTP and OPCV, be prepared for conclusions in the afternoon. Okay, well, thank you very much. We'll reconvene at 11:34. Thank you very much.
All rise, veuillez vous lever.